Tenancy Supplementary Provisions Act of 1949. Now, the districts of Santhal Pargana were formed in 1856, covering parts of Bhagalpur and Birbhum districts. This area was earlier called Jungle Tari Track. The residents within this region comprised mainly the tribals. The Jungle Tari Track itself is known as Damin Ilko. It was also called Narik Khand during the ancient times. This region has never been under control of any rule. The native of this region were the Paharia people. It is the peculiarity of this region that the holdings of zamindari records are listed in revenue records under Toji number. The owners and zamindars of these Tojis used to pay the rents and arrears of revenue to relevant district magistrates. This convention has been discontinued after the abolition of zamindari system. Santhal Pargana Settlement Regulation Act of 1872, the first act for Rayyats, was enacted in the region in 1872. This was the first tenancy act in Santhal Pargana region. This very act facilitated development of the concept of tenancy in Santhal Pargana. The then government of Bihar constituted the Santhal Pargana Inquiry Committee of 1937 after reviewing the settlement report of Mr. Ganzer. It was on the basis of the recommendation of this very committee that Santhal Pargana Act of 1949 was formulated. There are 8 chapters and 72 sections in this act. Now, the first chapter is short title, commencement and extent. This will be called the Santhal Pargana Tenancy Supplementary Provisions Act of 1949. It shall come into force on such date as the state government may declare by notification. It shall extend to the whole of Santhal Pargana comprising of the district of Dumka, Sahibganj, Godda, Deoghar, Pakur and Jamtada. Now, powers to vary local extent of the act and effect of the withdrawing of the act from any area. The state government may by notification withdraw this act or any part thereof from any portion of the Santhal Pargana division and may likewise extend this act or any part thereof to area from which the same has been so withdrawn. The withdrawal of this act or any part thereof from any area shall not affect the previous operation of this act in such area or anything duly done or done before such withdrawal. It will not affect any penalty, forfeiture or punishment incurred in respect of any offence committed under this act with reference to such areas before withdrawal. Now, definition. Agricultural year means where the Bengali year prevails, the year commencing on the first day of Baisakh, where the Fasli year prevails, the year commencing on the first day of Ashwin, and where the state government is the landlord, the year commencing on the first day of April. Now, Bhugut Bandha or complete unfacturatory mortgage means a transfer of interest of a Rayyat in the holding or part of the holding for the purpose of securing the payment of money advanced or to be advanced by way of loan upon the condition that the loan with all interest thereon shall be deemed to be extinguished by the profits arising from the holding or part of the holding during the period of mortgage. Now, Khas village means a village in which there is neither a Mool Rayyat nor for the time being any village headman, irrespective of the fact whether there was or not previously a Mool Rayyat or village headman in that village. Now, landlord means a person other than the village headman or Mool Rayyat entitled to receive rent and include proprietor, a tenure holder, a ghatwal and the government. Now, Rayyat means a person not being a landlord who has acquired a right to hold the land for the purpose of cultivating it by himself, by member of his family or by hired servants. A village headman shall be deemed to be a Rayyat in respect of his private holding, if any. Now, Santhal civil rules refers to the directions issued by state government for observance in the administration of civil justice in Santhal Pargana by officers appointed under Act 37 of Clause 2, Section 1 of Santhal Pargana Act of 1949. Now, tenant includes a tenure holder, village headman and Mool Rayyat. So, all these are tenants. Now, Chapter 2, that is village headman and Mool Rayyats. On application of a Rayyat or a landlord of any Khas village and with the consent of at least 2/3 of the Jamabandi Rayyats of the village ascertained in a prescribed manner, the Deputy Commissioner shall appoint a headman for that village. When the village headman of a village is not Khas, dies, the landlord of the village shall report the fact within 3 months of its occurrence to the Deputy Commissioner with a view to appointment of a village headman. A village headman on the appointment shall be required to execute an undertaking that he shall, in discharge of his duty, be governed by the rules made by the state government. Whenever a person other than the heir of last village headman is appointed by the village as a village headman, it shall be the duty of the landlords to provide him the record of rights of the village within 3 months from the date of appointment. The village headman shall have no right in transfer of his office in any way. Any waste land which is reclaimed by a Mool Rayyat or Co-Rayyats, or any vacant holding that is found in the possession of a Mool Rayyat or Co-Rayyat shall be treated as non-transferable Rayyat holding of a Mool Rayyat or Co-Rayyats as per provisions of this Act. All fines imposed upon the real and realized from village headmen, Mool Rayyats and Rayyats under this Act shall be deposited into a fund known as the Headman's Reward Fund. This fund shall be used on the order of the Deputy Commissioner. Now, Chapter 3, Rayyats, Section 12 to 26. There shall be the following classes of Rayyat for the purposes of this Act: resident Jamabandi Rayyats, Rayyats who reside or have their families reside in the village; non-resident Jamabandi Rayyats, Rayyats who do not reside or have their families' residence in the village; new Rayyats, persons recorded as new Rayyats, right of Rayyats regarding the use of land. Now, a Rayyat may use his land under his holding in any way as that is authorized under local customs or traditions, or in a way that is unexpected by local traditions and customs, but that does not destroy the value of the land or does not make the same unsuitable for cultivation. A Rayyat shall not be ejected from his holding by the landlord without an order by the Deputy Commissioner, Section 14. A Rayyat shall have the right to use his holding for making bricks and tiles for his own use without any license fee. Without any specific permission from the landlord, a Rayyat may build a dig embankment, a har, pond, well, etc. within the holding or settlement land, provided the same does not result into a damage for anybody else. In the case of an actual damage or potential damage, the Deputy Commissioner shall take appropriate decision. The Rayyat may use such water bodies for fish farming or similar activities without paying any fee. A Rayyat may plant trees, orchards, bamboo on any land in his holding and cut, fell, appropriate the same. However, no mahua tree shall be cut without permission from the sub-divisional officer. He shall have the right to grow lac or rear silk cocoon free of charge on tree planted by him on his holding. Now, Rayyat may erect kacha or pakka building on his holding for his family or his members, domestic or agricultural purpose. Now, Section 19, Division of Holding or Distribution of Rent. A holding may be subdivided and the rent thereof distributed with the consent of landlord and the village headman or Mool Rayyat, if any. When a holding has been subject of partition or subdivision by an order of a court or otherwise, and if the parties of the partition are unable to distribute the rent of the holding by agreement amongst themselves and with the consent of landlords and the village headman or Mool Rayyats, if any of the parties may apply to the Deputy Commissioner for distribution of the rent and holding. In no case shall a holding be subdivided if the rent or any portion of the holding is less than 3 rupees. Now, Section 20, Transfer of Rayyat's right. No transfer by a Rayyat of his rights or his holdings or any portion thereof by sale, gift, mortgage, will, lease or any other contract or agreement, expressed or implied, shall be valid unless the right to transfer has been recorded in record of rights. A lease of Rayyati land in any subdivision by a Rayyat for a period of not exceeding 1 year may be allowed with prior written permission of the Deputy Commissioner. Where gifts by a recorded Santhal Rayyat and a sister and a doctor are permissible under Santhal law, such a Rayyat may validly make such a gift with prior written permission of the Deputy Commissioner. An aboriginal Rayyat may, with the previous written permission of the Deputy Commissioner, make a grant in respect of his land not exceeding 1/2 of the area of his holding to his widowed mother or his wife for her maintenance after his death. Notwithstanding anything contrary contained in the record of rights, no right of an aboriginal Rayyat in his holding or any portion thereof which is transferable shall be transferred in any manner to anyone but aboriginal Rayyat engaged in bona fide cultivation of the Pargana or Taluk in which the holding is situated. Nothing in this subsection shall apply to the transfer made by an aboriginal Rayyat of his rights or his holdings, portion thereof, in favor of a Gardi Jami or Ghar Jami Besides this, as per Santhal Pargana Tenancy Supplementary Promotion Amendment Act 1975, a Rayyat who is a member of Aboriginal tribe or Aboriginal caste may, with the prior sanction of the Deputy Commissioner, and a Rayyat who is not a member of the Aboriginal tribe or Aboriginal caste may, without such prior sanction, enter into a simple mortgage in respect of his holding or a portion thereof, any scheduled bank within the meaning of the Reserve Bank of India Act 1934, or a societies or a bank registered under the Bihar and Orissa Cooperative Society Act, or a financial institution with a company or a corporation owned by or in which not less than 51% of the share capital is held by a state government or central government, and which has been set up with a view to provide agricultural credit to cultivators. Now, no transfer in contravention of subsection 1 or 2 shall be registered or shall be in any way recognized valid by any court in exercise of civil, criminal, or revenue jurisdiction. The rights of a Rayyat in his holding or any portion thereof shall not be sold in execution of any decree or order of any court or officer for the sale of such right unless the right of the Rayyat to transfer has been recorded in the record of rights. As per Bihar Act 17 of 1976, a holding or a portion thereof held by any occupancy Rayyat may be sold in accordance with the procedure laid down in Bihar and Orissa Public Demands Recovery Act of 1914 for the realization of loans taken from scheduled banks within the meaning of Reserve Bank of India 1934, or a society or bank registered or deemed to be registered under the Bihar and Orissa Cooperative Society Act 1935, Bihar and Orissa Act 6 of 1935, or financial institutions owned or in which not less than 51% of the share capital is held by the state government or the central government, or partly by the state government and partly by the central government, which has been set up with a view to provide agricultural credit to cultivators. But if the holding and portions thereof belongs to a Rayyat who is a member of Aboriginal tribes or Aboriginal caste, it shall not be sold to any person who is not a member of Aboriginal tribes or Aboriginal caste. If at any time it comes to the notice of Deputy Commissioner that a transfer of land belonging to a Rayyat who is member of scheduled tribes as per specified in Part 3 of Schedule to Constitution Order 1950 has taken place in contravention of subsection 1 or 2 by any fraudulent method, he may, after giving reasonable opportunity to transferees to show cause and after making necessary inquiry in the matter, evict the transferee from such land without payment of compensation and restore it to the transferor for his or his heir, or in case heir is not available, is not willing to agree to such restoration, resettle it with another Rayyat belonging to the scheduled tribes. According to the village customs for disposal of abandoned holdings. Now, if a transferee has within 30 years from the date of transfer constructed any building or structure on such holding or portions thereof, if the transferor is not willing to pay the value of the same, the Deputy Commissioner shall order the transferee to remove the same within a period of 6 months from the date of order, or within such extended time not exceeding 2 years from the date of order as the Deputy Commissioner may allow, failing which Deputy Commissioner may get such building or structure removed. Now, where the Deputy Commissioner is satisfied that the transferee has constructed a substantial structure or building on such holding portion thereof before coming into force of Bihar Scheduled Area Regulation 1969, he may, notwithstanding any other provision of the Act, validate such transfer, where the transferee either makes available to the transferor an alternate holding or portion, or as the case may be, an equivalent value in the vicinity, or pays an adequate compensation to be determined by Deputy Commissioner for rehabilitation of the transferor. If after an inquiry the Deputy Commissioner is satisfied that the transferee has acquired a title by adverse possession and that the transferred land should be restored and resettled, he shall require the transferee or his hired or any another Rayyat, as the case may be, to deposit with the Deputy Commissioner such sum of money as may be determined by Deputy Commissioner, having regards to the amount for which the land was transferred or the market value of the land, as the case may be, and the amount of compensation for improvements affected to land which the Deputy Commissioner may deem fair and equitable. Now, Section 21, transfer of Raiti land by Bhugut Bandha or complete unsuffictory mortgage by a non-Aboriginal Rayyat and its limit. Notwithstanding anything contained in the Section 20, the government may by notification in this behalf publish in the official gazette forbid non-Aboriginal Rayyats either or whole of the Santhal Pargana or such portion as it may be considered desirable to transfer with effect from such date as may be notified their rights in the holding up to the extent of 1/4 of their paddy and first class bari lands by Bhugut Banda or complete unsufficatory mortgage. To a land mortgage bank duly established by state government or a grain gola approved by the deputy commissioner or a society registered or deemed to be registered under the Bihar or Orissa Cooperative Act Societies Act of 1925 or a Raiyat of the Santhal Pargana. No such transfer shall be recognized as valid unless it has been made by the means of a registered deed and reported in the prescribed manner by transferor and transferee of the to the deputy commissioner and to the landlord within 1 month of the registration of the deed. No such transfer shall be made for the period exceeding 6 years. On expiry of the period of the transfer, no further transfer of any land of the transferor Raiyat shall be permissible for a period of 6 years. Now, cost as required for the process of transfer and redelivery of possession after 6 years shall have to be deposited with the deputy commissioner. The transferee shall not be valid without the same. The transfer shall pay the rent of the land at the settlement rate for the area and shall be ejected immediately with cancellation of mortgage on his failure to do so. On expiry of the period of mortgage, the deputy commissioner shall, on his own motion, cause a notice to be served on the parties to the transaction that the period of the mortgage has terminated and shall proceed to evict the transferee and deliver possessions to the transferor Raiyat. Any transfer of land made otherwise other than under provided provisions of the foregoing subsections shall be deemed to be transfer made in contravention of subsection 1 of section 20. Any mortgage found in possession of any land belonging to a Raiyat after the expiry of period of such mortgage shall be punished with imprisonment. Now, section 22, a Raiyat may make over his holding temporarily on trust for cultivation, notwithstanding anything contained in this section 20 and 21, in event of a Raiyat's temporary absence from the village or his sickness or physical incapacity or loss of plough, cattle due to any cause beyond his control or the Raiyat being a widow or minor, he may, after informing by prescribed post the village headman, Mool Raiyat or landlord or any case may be and the subdivisional officer, hand over his holding temporarily on trust for cultivation to Raiyat of the Santhal Pargana in cases covered by subsection 1. If no period has been stipulated and the Raiyat does not resume cultivation himself, holding shall be presumed to be abandoned after the expiry of period of 10 years. Any transfer of holding for cultivation, temporary or otherwise, made otherwise than under the provisions of the subsection 1 shall be deemed to be a transfer made in contravention of subsection 1 of section 20. Now, exchange of Raiti land. Raiyats desiring to exchange their land may apply in writing to the deputy commissioner. However, the deputy commissioner shall not permit an exchange to be made unless he is satisfied that the parties to the exchange are Raiyats with respect to the respective lands proposed to be exchanged and the land proposed to be exchanged are situated in the same village or in contiguous villages, and the transaction is not a concealed sale but is a bona fide exchange sought to be made for mutual convenience of the parties, and the land proposed to be exchanged are at the same value. In cases covered under the subsection 1, if no time period have been stipulated and the Raiyat does not resume cultivation himself, the holding shall be presumed to be abandoned after the expiry of a period of 10 years. Any exchange of land made otherwise than under the provisions of the subsection 1 or without a written permission in writing of the deputy commissioner shall be deemed to be a transfer made in contravention of section 20. Now, section 24, registration of certain transfers of Raiti holdings, sale, gift, will or exchange of a Raiti holding in accordance with the provisions of this act, and the records of rights shall be registered in the office of landlord, notwithstanding anything contrary contained in the record of rights or any law or anything having the force of law in Santhal Pargana. The landlord shall allow registration of such transfers and shall be entitled to levy a registration fee in case of a transfer by sale, gift, deed, or will. No fee shall be levied otherwise in case of a gift to husband or wife or for donor or to a son adopted under Hindu law or to a daughter or sister adopted under or adopted daughter of a donor under Santhal law, to a relation by contiguity within 3 generations. No registration fee shall be required to be paid to the landlord. If any landlord refuses to allow registration of such transferee as mentioned in subsection 1, the transferee of his successor in the title may apply to the Deputy Commissioner. Now, Section 24A, registration of certain transfers of homestead. When a homestead or any portion thereof which a Rayyat hold otherwise as a part of his holding as a Rayyat is transferred by sale, gift, will or exchange in accordance with the customs or records of right of exchange, the transferee of his successor in interest may cause the transfer to be registered in the office of landlord of the village, notwithstanding anything to the contrary contained in record of rights or in any law or anything having the force of law in Santhal Pargana. The landlord shall allow registration of such transfer and shall not be entitled except in the case of a transfer by sale, gift or will to levy any registration fee. If any landlord refuses to allow registration of such transfers as mentioned in the subsection 1, the transferee of his successor in the title may apply to the Deputy Commissioner. Section 25 and 26 contain details regarding the process of transfer of a holding of a Rayyat by sale or gift. That will be all for this video. In the next video, we'll be starting with chapter 4.